Welcome to Buzzed and Baffled, the podcast where the wine is flowing and the stories are strange.
Each week, we uncork a bottle, take a sip, and dive into some of the most jaw-dropping, unbelievable true tales you've never heard before.
From historical mysteries to bizarre real-life events, we'll have you wondering, is this for real?
So, grab your glass, sit back, and join us as we get buzzed and you get baffled.
Hey listeners, just a quick note before we dive in. Buzzed and Baffled is a podcast where we enjoy a glass of wine, share wild stories, and sometimes get a little, well, buzzed.
While we strive to share true and accurate tales, we're here for the entertainment as much as the facts. So take everything we say with a grain of salt and a splash of wine. Any opinions shared here are our own and do not reflect those of any other party.
Always drink responsibly and remember, the truth can be stranger than fiction.
Okay, welcome back, Kyla.
Here we are, episode
5.
Episode 5, which is episode
4B.
B, yep.
I know some of our fervent listeners were unhappy that there was a break.
Yeah, sorry.
But we're here for part 2 of the Bernie story. Tonight's wine is, surprise, surprise, a Sauvignon Blanc.
Who would have guessed?
I mean, we're still waiting for Boda Box to at least acknowledge us in social media.
Like, even if they block us, like, just give us something.
Like, let us know you're getting our messages. But, you know, they'll notice us eventually. We just have to keep trying.
Yeah.
That's what I've been told has to happen.
Yeah, and you're nothing if not persistent.
That is true. That's how I got her to be my friend. So
Yeah.
I tricked her. So, tonight's wine is a Fry Brothers Sonoma Reserve from the Russian River Valley. I found this one because I was on the hunt for a wine for a future episode, and this was of the same vintage than that one was. So this one is from the River Valley, which has a lot of limestone in it. So it is, what do I like, Kyla?
Minerals.
Minerals. I like
Licking
to be
river stones.
I like it to be so dry and minerally. And that's what this is. We were actually surprised by how good it was.
Yeah, it's really good.
When we were eating it with our very gourmet Chinese food for dinner.
A succulent Chinese meal.
Mm-hmm. It went really good with crab rangoons. Highly recommend.
Yep. Really good for your seafood allergy. Those crab rangoons.
And the lactose intolerance.
Yeah. Like the cream cheese and crustaceans really do you good.
Like nothing but good things are going to happen for me tonight. But I will put the bottle on our Instagram, so if you are interested in trying it, I highly recommend it. It's in the $20 to $25 range, so not maybe an everyday wine, but a good special occasion weekend wine.
Yeah, it's a little higher than a lot of the wines that we drink. Not because we're cheap, but just because we like the ones that we like.
Yeah.
But even that's still really reasonable.
Yeah, like I wouldn't not buy it just
Yeah.
because it's $20, $25.
Yeah, it's like, if you're going to spend $18 on a wine, you don't really like spend the extra $2 for this one, so.
Yes. Well, and like, after doing the research for the future episode, I'm not so shocked by wine prices after what the bottle prices I was looking at. I was like, well, we will never taste that, so I can only guess. So, tonight's episode, part 2, is called Putting the Lit in Litigation, is what I've entitled it.
Ooh, you and your witty titles.
So, at the end of the last episode, we learn that Bernie won a post-conviction writ of habeas corpus, and he was released from prison on bond. So, the interesting thing is that he was released to the man who produced the movie Bernie.
Oh, okay. So, yeah, because I remember the movie brought up all this new stuff, which is actually kind of unusual that you have a fictional or a piece of media come out, you know, for entertainment, but it actually helps someone's cause.
Well, and I guess also it probably had a lot to do with the fact that the view of trauma and abuse had changed so dramatically from, 1999 when he had his first conviction to 2012 when the movie came out.
Yeah, there was a lot of reduction of stigma in popular culture, especially. There were a lot of campaigns, celebrities, mental health and trauma and abuse kind of came to the forefront where it wasn't so taboo to talk about.
Well, and like we're seeing that with the Menendez brothers right now. I just saw in the news this week that they're recommending redoing their sentencing.
Yep. Yeah. And that's, if that occurs, that's probably going to result in their release because they've been in jail for how long now? Like 30 something.
Yeah. Most of their life. They've been in jail longer than they have not been in jail over the course of their life.
Yeah. Because they're like 19 and 21 or 20 and 24 or something like that.
So, something that, as I was listening to this story and researching it, one of the big things that came up to me was, why was it not double jeopardy? So I'm going to say, what is your understanding of what double jeopardy is?
So double jeopardy, and to our lawyer friends who are our listeners, which I don't think the 2 lawyer friends that we have listen to our podcast, but if they do,
we know that they would love to tell me why I'm wrong.
Yes. Maybe we'll have to put something special like Lauren and Brittany listen to this and post something in the comments. But my understanding of double jeopardy is once you have been tried and either accused or acquitted, you cannot go through the same charges again with unless new substantial evidence comes to light that would potentially change the outcome. So if you were acquitted, something that would find you guilty.
Yeah. And so the answer was, because he wasn't acquitted, he was found guilty. And now they're saying, yeah, but maybe we need to revisit this because we have new information. Since he wasn't acquitted, it's not double jeopardy. And that's why this, trial can happen. So he gets released from prison. He just goes down to Arizona, is living in this producer's garage apartment, just hanging out, doing whatever you do when, you're, I'm assuming, on house arrest.
Yeah, he would have been on some type of, whether it's parole or some type of supervision.
He's monitored.
Yeah, he's going to be monitored during this interim phase.
So I'm going to ask the question, what do you predict happens in this appeal process?
Oh, boy. In the appeal process, I think the police are going to be involved and probably have to answer for their blackmail. And when they were basically saying, confess to this or else we're going to reveal that.
We're going to release your sex tapes.
Yeah. I think that's going to play a big part.
Coercion.
Yep.
So what do you think the outcome is going to be?
I think he's going to be acquitted on appeal. Or have a reduction in sentence due to mitigating factors.
Okay. So, the thing is, we look at the new evidence of sexual abuse, and we find that his story is corroborated by others. So it's not just him and this producer saying, yeah, all this sex abuse happened. They found 3 other men who came forward to say that the uncle, whose name was Elmer Doucette, also molested them when they were young.
And just a real quick side trip back to the Menendez brothers. I don't believe, and when I say I don't believe, it's I don't think or remember hearing, not that my personal beliefs. I don't believe there was corroboration, third-party corroboration necessarily of, maybe by a cousin. There was maybe a cousin.
I think there was a cousin to which there was a letter written, and maybe there was evidence of the letter.
Yep. I don't think it was as strong as this, where 3 people came forward and said, yes, this happened to me too.
Yep. And so good old Elmer Doucette wasn't dead. So they talked to him about it. And so when he was interviewed by the police, he states he didn't recall having sexual relations with Tiede, teaching him how to masturbate, or showing him pornography. Well, those are very specific things that you don't remember.
That's like the police going and saying, hey, did you molest this kid? And he's like, no, I did not do any of these 3 extremely specific things that you didn't explicitly ask about.
Yes. And so in 2011, so that was prior to this, those 3 men brought charges against Elmer in Louisiana. But the statute of limitations had expired, which is why there should not be a statute of limitations on sex crimes.
Agreed.
Especially males are much less likely to come forward and admit that.
Mm-hmm. And I think, and I'm sure our lawyer friends can chime in if I'm wrong, I think some states, or maybe this is across the country now, The statute of limitations actually starts when the victim turns 18, which allows them time to become adults. So
Understand what's happening.
Yeah, so if the statute of limitations is 5 years and you're molested at age 13, that clock doesn't stop until 5 years after you turn 18.
That's smart, and I hope that's true.
Yep.
So, as a result of this evidence and the work of his attorneys, because he got new attorneys who were like, hey, this is bullshit, we need to do something about this. In 2014, the district attorney, Mr. Where is he up there?
The prosecutor?
Yep.
The one who very nobly said, oh, yeah, we have more information. That changes everything.
I can't read his name from here. But...
Oh, I don't remember what it is. It's like Gary Dale or something like that. It's like 3 names. Ricky Buck.
David Buck Davidson.
Okay.
So, the district attorney who prosecuted him, Davidson, agreed to early release of the life sentence, and that he was then released by the judge. The court paperwork shows that the psychiatrist who initially assessed him determined that Bernie lacked future dangerousness. So
his crime was a one-time. He was not going to be a danger again.
Yeah, this happened with Marjorie, but it's not like he's a repeat offender.
Right.
Unless he gets somehow into another weird, abusive, platonic relationship with a mean dragon lady.
Yeah. Which, I mean, Bernie, let's keep it on the straight and narrow here. Let's watch who we hang out with.
We got to start looking at our red flags in people so that we're not making the same mistakes over and over. So, and it also said, he had an excellent record of good behavior in the 16 years he's been in prison. So it's very unlikely that he's going to commit a similar act as long as he continued with his mental health services to address the trauma.
Okay, yep.
So, he was ordered to live with the Austin-based filmmaker Richard Linklater. So he's the one who made the movie Bernie. In May 2014, Davidson signed an affidavit where he states that when he requested life in prison, he was not aware of the childhood abuse, and after reading the psychiatric evaluations, he now believes that Bernie's childhood trauma paired with other factors, and that he now does not believe that he's a danger to society and that life in prison is not an appropriate sentence for him.
That's really, like I said, this guy could have wanted to not that he was wrong in the first place, but he could have held on to that first way of thinking, that first conviction for life, just because he wanted to save face. Mm-hmm. And
he's like, no, I have new information. Yeah. I have critical thinking skills.
Yeah. So we need to look at this again and not just say absolutely not and be done with it.
Yeah. He's like, my ideas have changed based on new information, which is how it should be, not digging your heels in because you refuse to admit you were wrong.
Yep.
So, he was released in 2014. He was on an order that he had to live in the director's Austin home, and he was not to speak to the news media. That was something. It's like, nope, cone of silence. He abided by the rules, and he said that in majority he did that because he wanted to show respect for Marjorie's family.
Oh, yeah. I mean,
he knew that they were going to be impacted by his release. So while he lived with Richard, Bernie just stayed in his garage apartment. So, how do you think Bernie's family reacted to his release? And remember...
Bernie's family or Marjorie's family?
Sorry, Marjorie's family. Because Marjorie's family, remember, was all estranged from her because she was not the most nurturing awesome type.
I'm going to guess that they were like, oh, hey man, thanks. Do you, need money or something?
That is not what happened.
Oh, that's actually surprising because, I mean, not that they would, open arms to the person who killed their family member, but judging by how terrible she was, I'm surprised that there's not a little bit of relief on their part.
No. So, the son and the nephew and everyone, they determined that this is inconceivable and unacceptable for Bernie to be released then of their sweet, sweet Marjorie is no longer with them.
Yeah, now she's sweet because she's dead.
Well, and also there was millions on the line.
Mm-hmm.
So they began to kind of put the screws to Mr. Davidson to get him to recuse himself.
Oh.
So, and they say it was extremely unusual and aggressive pressure from some, not all of the descendants, from the case and the plea deal allowing the release for the time served. And they went as far as a lawyer sent a several-page letter to the attorney, which, good news for you, I have a copy of.
Had she amended her will?
She wrote her son out of the will, and Bernie was the person named.
Yep. So, okay. And with Bernie being out of prison, he's now eligible.
See, I don't know. That's probably on the line because you cannot profit from a crime you committed. Right. So if you were convicted and you were still convicted of murdering her, you don't get the inheritance.
Right, because he's still convicted.
But if it's overthrown or he wins the appeal and he's no longer convicted, he would then probably be eligible for that payout.
Yeah, so they don't care that dear old mom is dead. They are worried that their money is going to be funneled to Bernie now instead of them probably winning in probate, because if the person named in the will is in prison for killing the person of the estate.
I mean, that could be a motivating factor. We don't know. So this letter from their attorneys states, "Dear Mr. Davidson, as you know, I represent Rod Nugent, not Todd Nugent."
And also, I know you probably mean Ted Nugent.
Yes, that is who I mean. But remember, Rod Nugent, not Ted or Todd, is the son. The only child of Marjorie M. Nugent and his 4 children. You will recall my June 17th, 2014 letter through which Mrs. Nugent's family sought to obtain information from you relating to the habeas corpus proceedings. We were disappointed that you did not respond to this letter. The family of Miss Nugent asked me to send this letter to request that you recuse yourself and your office from representing the state of Texas in Mr. Tiede's new sentencing trial for his murder conviction. The family further requests that you ask the trial court to appoint an assistant attorney general to represent the state in that matter. Article 207B of the Texas Code of Criminal Procedure permits you to recuse yourself and your office, even if you were not otherwise disqualified. Article 207F of the Code authorized the Assistant Attorney General to serve as the prosecuting attorney. Texas law imposes upon prosecuting attorneys the duty to avoid conflicts of interest, even the appearance of impropriety, by deciding not to participate in certain cases. We are concerned about your objectivity and the possibility that you may have violated ethical rules governing prosecuting attorneys in your zeal to see Mr. Tiede released from prison. Our concerns about your objectivity are based on your well-known interactions with Richard Linklater and other associates of the movie Bernie, your recent published statements and activities, and evidence in the possession of the Pinole County Sheriff's Office, evidence you failed to disclose to the tribunal considering Mr. Tiede's habeas corpus application and endeavor to hide from the public. So, these are big. They're saying, hey, buddy, you've been unethical. You need to recuse yourself. It's very much a shots fired.
Yeah.
Simply put, we believe your recusal is absolutely essential and required by applicable ethical rules. Here are a few examples leading us to these conclusions. You made the following statement to the Palestine Rotary Club in August 2013. She, meaning Miss Nugent, was killed in November and was discovered the next August. Now, what do we have during that time period? We got Thanksgiving, Christmas, Mother's Day, her birthday. Her family was not looking for her, but they got real mad when they found out he'd spent a bunch of her money after her death, about $6 million worth.
Oh, that's a lot of money. But he put it to good use, right? And I'm not condoning what happened here, but he didn't just buy a yacht for himself.
No. So these statements show your inappropriate and disrespectful attitude toward my client, your lack of concern for the victims of Mr. Tiede's crime, and your current bias in favor of Tiede. In fact, these statements likely constitute legal slander against the victims in this case. Likewise, although you are not hesitant to disclose in a public forum that you have evidence showing that Tiede stole about $6 million from Miss Nugent after her death, you'll go to great lengths to avoid allowing the evidence to be released to the Nugent family or the public. So part 2 is Variety newspaper stated that the following article published in June of 25th, 2014. What didn't get reported immediately was the fact that Tiede's release marked the accumulation of roughly 2-year concerted effort by Linklater and others, chiefly Danny Buck Davidson, the district attorney who prosecuted Tiede for the 1996 murder of his 81-year-old companion, Marjorie Nugent. Their goal, to reduce Tiede's sentence to time served, 17 years, in light of new facts dug up by Jody Cole, a local attorney who became intrigued by the case after seeing Bernie, the movie, and discussing it with Linklater at the film's Austin premiere. We were shocked to learn that you had been working in tandem with Tiede's defense team over 2 years to obtain his release. This certainly shows a conflict of interest in your continuing to serve as the prosecutor. I mean, they're not wrong there.
No, and he has the right mindset, but I don't think he went about it the right way.
He's not in the right position to be doing that. Moreover, you took these actions without any notice to my clients. But also, he doesn't represent the children. He represents the state. Mm-hmm. And so he doesn't have any obligation to do that. Although we would have preferred to obtain the information directly from you or your office, your refusal to engage in any communications with the Nugent family has resulted in our having to rely on third-party sources for a portion of our information. So the third thing they're stating is, hearing of the writ of habeas corpus, and then they're outlining the lines. And so Mr. Davidson says, Your Honor, at this time, I would like to read into the record my affidavit as it had been filed. I did not know that Mr. Tiede had been sexually abused as a child, and I did not know the extent of the descendants' encroachments on his reasonable boundaries. The decedents. Encroachments onto his reasonable boundaries. So basically, I didn't know he was previously abused, and I didn't know she was abusing him, which, frankly, questions you should have asked.
Yeah, that seems like... But, I mean, as the prosecutor, you want to prosecute the person.
But also the police didn't do their job.
Well, we know how the police worked on this one, so...
These issues are thoroughly explained in Mr. Tiede's latest psychiatric evaluations. In consideration of the opinion and the affidavit of my punishment expert, Dr. Edward Brown Gripon, MD, the psychiatric evaluation of Dr. Richard Pesikoff, and new mitigating evidence presented by the defense, and my own independent investigation, I have made new, fully informed assessments of the circumstances surrounding the shooting event and Mr. Tiede's lack of future dangerousness. I now feel that a life sentence is inappropriate for Mr. Tiede. So, because Dr. Gripon did not evaluate Tiede for you the second time till January 24th, 2014, and did not provide you his report until after that, based on the affidavit testimony, you did not make your new fully informed assessment of the circumstances until at least January 2014. Yet, as discussed above, you were allegedly engaged in a concerted effort with the defense team to obtain the release for Mr. Tiede for over 2 years. Accordingly, you worked for Mr. Tiede's release long before you had any evidence to support that effort. This established both a conflict of interest and a lack of candor toward the tribunal. Not wrong.
Yeah, I totally hear where they're coming from a standpoint of you said some stuff and did some stuff. So the first time you convicted him, you didn't have all the information. But also, when you wanted his release, you did it before a lot of this other stuff came out too. His second psychiatric evaluation and all that sort of thing. That's what it kind of sounds like.
Yeah. And so and if you want to read the full letter, guys, you can go online. I have the link to it posted. So if you go to buzzedandbaffled.net, you can find this episode, the behind the scenes stuff, because I'm not going to read this whole thing because I'm butchering some of these legal terms. but I'm going to skim through this.
You're doing so good, though.
I'm trying so hard. So one of the things they talk about is about the sheriff, because this is something we had said, what's going on here? So statements in an October 10th, 2004 letter to the Honorable Greg Abbott from Robert Underwood Esquire, as attorney for the Panola County Sheriff Kevin Lake. This information is also relevant to the specific investigation and prosecution in the possible new punishment trial in the murder case since Tiede acted in a knowingly deceptive course over several months by withdrawing several large sums of money and spending it or giving it away. This conduct may be relevant to explain why Tiede murdered her and hid her body in a freezer. The concealment of the body and the deception in the withdrawals appears contradictory to the sudden passion emotion as stated is something that we're discussing earlier. The deceptive conduct and the deliberate acts of Tiede for a period of 9 months after the murder is relevant to prove the intentional murder and to refute or counter the new evidence that arose in the writ hearing. The information withheld contains dire evidence of this conduct after the murder. Based on your published statements to the Palestine Rotary Club, apparently that evidence shows the withdrawals of money for approximately $6 million. As stated above, this shows that you have access to evidence that is contradictory to the sudden passion and emotion argument, and additional evidence that rebutes or counters the new evidence which you represent to the trial court at the habeas corpus hearings as being established feat. This further demonstrates your bias, conflict of interest, lack of candor, the trial court, the inability to continue to serve as the prosecuting attorney. The collection of 76 tapes as a whole is relevant information to the cross-examination of Tiede or the reputation witness or the direct cross or expert opinion testimony from behavioral or mental health experts in the punishment sentencing phase of a criminal trial for the brutal murder of an elderly woman or for the theft of a large sum of money from an elderly woman with a deception over a long period of time. It is overall nature or theme of the tapes which is relevant. So basically they're saying, hey, yeah, we found these tapes and we blackmailed him, but it's still relevant because this speaks to his character. Which, these are tapes that he made of sexual encounters that were private in nature with willing partners.
Yep, and I don't see how that is relevant to the murder of Marjorie. It's unrelated.
Well, and realistically, the attorney writing this letter is ignoring the fact that the police really screwed the pooch on this investigation.
I think it's really sad that they're trying to, regardless of what he did and what people think of him, defame him for having homosexual encounters. That's kind of going back to when homosexuality was listed as a mental disorder in the DSM.
Yeah.
It's not. And just because, someone engages in a consensual encounter doesn't say anything about their character and who they are as a person.
Yeah. So this letter goes on for like 3 more pages, which is why I am not going to read it in its entirety. But they're very much, what it comes down to is that this family is putting a lot of pressure on Davidson to recuse himself because they want him to have no part in this retrial.
And I see where they're coming from, but I'd feel a little bit differently if I knew it wasn't just about the money. If they actually cared about their mother, I mean, like this attorney said, all these holidays came and went and no one knew she was dead because they did not want anything to do with her. It's all just about the money.
So, what do you think Mr. Davidson did?
Oh, that's a tough one because I know he seems to be a pretty decent guy because he tried or wanted to, take these.
He wanted to right what he viewed as a wrong.
Yep. But I'm going to guess he did not recuse himself. Dang it, wrong again.
So, In 2015, Mr. Davidson recused himself.
Oh, well, good. I mean, like, that's what I was hoping for.
After what the lawsuit claims was an extremely unusual and aggressive pressure from the decedent's family. So, new people were assigned to the case, and he was retried. What do you think happened?
I'm going to guess that the outcome was the same, that he was found guilty, but was sentenced to time served due to these mitigating factors. Oh my God.
So no, the retrial happened in 2016. He was again convicted and sentenced to life in prison.
Oh no!
So I'm going to update the board.
The board. I'm not doing so great on the trivia.
This is the only time I am really winning, and it's only because I have all the answers in front of me.
This game feels rigged.
I like this game. Convicted.
And in 2016, I would have been, like, career switching and not paying attention to the news. And it's possible that this didn't make national headlines because I don't remember anything about this beyond the movie.
I've never seen the movie, so I have no idea.
It's a good movie. Everyone should watch it. It's good. I mean, it's lighthearted. It
has Jack Black in it. There is a link to it on the webpage, so like you can find it. So do you think the story ends here? He's convicted and 2016 and he just sits in prison? And
well, I hope I don't go 0 for 4, so I'm going to say, no, the story doesn't end here.
Because she sees several more pages in my lap. So, that does not end. He's in prison. He's in Texas. But in August 2023, a motion was filed against the state of Texas for unlawful conditions of confinement and wrongful imprisonment. The lawsuit claims that the prison that housed Bernie had dangerous and deadly conditions with heat going to the triple digits, later stating it was above 120 degrees Fahrenheit.
Oh my gosh.
Resulting in stroke symptoms that needed medical transport to an emergency room. The lawsuit also states that he'd been wrongfully incarcerated after his 2014 release and subsequent retrial, and he is seeking ex parte temporary restraining order, injunctive relief, and declaratory relief. And that his constitutional rights were violated by not being fully released to the community with supervision in 2016. The lawsuit went on to state that Bernie did not receive time toward his sentence for the time served under community supervision from 2014 to 2016.
Oh, okay. So they're saying he was supervised, but they didn't count that.
So he wouldn't be fully eligible for parole until 2098.
Oh, why even bother?
The lawsuit claims that there's evidence that Bernie was abused by an uncle who they described as a serial pedophile, and that there is new evidence of a higher level of abuse by Marjorie during she and Bernie's friendship. It does not specify within the document, which is also on the website. You can find the whole court document on the website. So it doesn't say what this higher level of abuse was, but I'm guessing it's probably something similar in nature.
Yeah, that would be my guess as well.
So the said abuse is what they claim led to the dissociative state when he murdered Marjorie, supported by a psychiatric evaluation in the second trial. And if the murder happened in a dissociative state, it cannot be labeled as premeditated, which would lower the sentence to no more than 20 years from life. He had served 15 at the time of his release in 2014.
Yep.
The lawsuit also cites problems with the first trial, stating that Dr. Mears, the first psychiatrist, was not aware of the sexual abuse that Bernie experienced, not the alleged abuse he had experienced for Marjorie when he did his assessment and offered his opinion to the court. This new evidence would have been likely to enhance Dr. Mears' opinion when he testified to the court. Dr. Gripon, the second psychiatrist, assessed Bernie January 24th in 2014, and with this new information and the review of Dr. Mears' tests and court testimony, he testified that while Bernie is not currently mentally ill or suffering from any current medical disorder, Dr. Gripon stated that based on reasonable psychiatric probability, a review of his history and history of offense that would be described that he did have a dissociative episode at the time of the murder.
Mm-hmm.
So, like, he hasn't had a dissociative episode since then. It's very much something was happening in the environment.
Yeah, this was a one-time in that exact specific environment.
It was the perfect storm.
Yeah, exactly.
Whatever was happening triggered his trauma response.
Mm-hmm.
He disassociated, and he did what he needed to do to keep himself safe as he saw it at that time. So it would appear that the totality of his history of sexual abuse, his abusive negative relationship with the victim, and the culmination of other emotions resulted in an act of sudden passion and emotion. The court finds that there is reasonable probability that a dissociative episode could have been involved in this offense and the subsequent behavior of the defendant. So, remember, the police forced him to sign something saying that it was premeditated. Right. If you're disassociating, you're not, it's lights on, nobody's home.
Yeah, you're not in your head. You're walking, you're sleepwalking is what you're doing.
Yeah, like your body's moving and like you're talking, but like you're not encoding memories at this time. You're not responding to
your
things.
brain and your body are two separate things. They're not communicating.
So, if we look at the math, he served 1999 to 2014, and that's 15 years. And from 2016 to 2025, he served 9 years.
Yeah, so
he's over the 20-year sentence at this point.
For the what we would call second
degree. And that's not including the 2 years that they didn't count when he was under essentially house arrest. So the lawsuit claims that the retrial that occurred between 2016 was wrongful as the prosecutor and the Court of Criminal Appeals granted his release. However, when Marjorie's family began to interfere with Bernie's case with their own legal filings, and eventually a new attorney general was appointed. So the family interfered with the case.
Yeah, because they said, oh, yep, time served, you're good. And then the family all comes in mad, pretending they love mom.
But also they started filing things not related to the criminal hearing, which led to Davidson's recusing himself and a new attorney coming in. And that interfered with how the case went. And so they're saying this violated Bernie's rights.
Yeah, because he essentially didn't get a fair retrial with this new attorney. Because, and it's kind of fun. And I'm not saying funny in a ha-ha way, but it's kind of funny because they're saying, oh, this prosecutor needs to recuse himself because he has all this other knowledge. Well, they're doing the same thing with this new prosecutor that they want appointed.
Yeah. And I'm assuming wanting it to be someone who's in favor of them, because obviously that's what they want.
And did you say it was Greg Abbott who was the new prosecutor? I know you mentioned it, and I think he went on to become the governor of Texas.
I don't know. I don't have the names written down.
If he was the new attorney general.
I bet you if you Google it, you could probably look it up.
I'll look up later. We'll post an addendum on the website.
So, they're like, hey, this is problematic. So they state that the new attorneys were aware of the constitutional violations, which was the blackmail, as well as the psychiatric report of the dissociative episode. The lawsuit also makes allegations that the prosecution challenged the idea that Bernie had been sexually abused, even when the perpetrator and 3 other victims corroborated this. Yeah. So they're like, never mind this, nothing to see here, keep moving.
Yeah.
So the lawsuits questions the honesty of the new prosecution as they claim that all the evidence was always in possession of the Panola County Sheriff's Department. However, during the second trial, they presented financial evidence of financial abuse of Marjorie not shared with the defense.
That's a Brady violation.
And states that the prosecution was not able to show a clear chain of custody.
Oh, that's a big deal. So, I mean, this county sheriff's office really needs to clean up their act.
Yes, very much so. Let's see where. So this document is still admitted into the record in the second trial. So they have a record of financial abuse that they're saying, but they have no chain of command. They're ignoring the sexual abuse, and the very sketchy document that the defense has not had a chance to look at is still admitted. The lawsuit claims that Mr. Davidson had to recuse himself because he was a witness to impermissible events and conducts that were reported to the AOG. I wasn't able to find any information about what this was, and I looked. Trust me.
I believe you.
I looked, and we have a 2 episode here, so I dug and I dug and I dug, and I could not find out what it was. It should also be noted that the Nugent family filed a motion to force Mr. Davidson off the case, claiming there was at least 3 instances in which Mr. Davidson himself could be called to testify to the trial, which causes an ethical, you can't be a prosecutor and a witness.
Exactly.
So, that's his bad. Don't be a part of the movie, and don't be a part of trying to get him out of jail. You can't do both things. Yep. So, that is an ethical violation. These are the instances in which Davidson made statements in support of Bernie, as well as that he assisted Richard Lancaster. So the Nugent family claimed that Davidson was sitting on key evidence of theft regarding their belief that Bernie stole from Marjorie and the money was the primary motivating factor for the murder, but they're ignoring the sex abuse. So in April of 2015, Judge Diane DeVesto removed Davidson as prosecutor for the second murder trial and appointed Jane Starnes and Lisa Tanner. So I have the names. Okay. There we go. Okay, so, and that's kind of there isn't we don't have a lot of movement on this. This is all still in play.
Okay, yeah, because this was this was late 2023, right?
Yeah.
We're early-ish 2025, and we know the wheels of justice turn slowly.
Yes, so basically, the unlawful conditions, and it's not just Bernie that this is affecting, in 2020, they looked, and about 14 inmates die every year because the conditions are so terrible in the prisons, and it's so hot. In March of 2025, a federal judge ruled that the prison heat conditions are unconstitutional.
Mm-hmm. I think I remember reading that on the news.
But the ruling does not require that prisons have air conditioning. There are currently 5 bills that have been filed in Texas that would require air conditioning in prisons, but there have not been any hearings on any of these bills to date.
Shocker.
It should be noted that Texas law requires that county jails be kept from 65 to 85 degrees, not 120.
Mm-hmm.
Right now, there is a heat sensitivity screening to assess prisoners who have medical conditions that make them more sensitive to heat. And right now, approximately 12,000 prisoners are being rated as heat sensitive, and they get priority for air-conditioned housing. Georgia and Louisiana also have lawsuits regarding heats in prison.
That's not surprising. And, I know people are in prison, and it's easy to say, well, they don't deserve. So their sentence is to serve time in prison. It's not to die from heat stroke.
Yeah. We're not locking them in a box and letting them stroke out.
Humanity needs to be better than that.
Because if it's not, we're no better than the people who are in the prison.
Exactly. Yep.
So right now, Bernie's only kind of Hail Mary for getting as screwed over as he did by the police and the court system fucking everything up is this loophole of the heat in the prisons, and this is why everything's unconstitutional. So right now, the court case is pending, and there's a jury trial scheduled for March 30th, 2026 at 9:30 a.m. in front of Judge Robert Pittman.
Well, hopefully the pot will still be going, and hopefully in maybe April of 2026, we can do a recap, and hopefully
we can do a quick 15-minute follow-up episode.
Hopefully Bernie will be free. I'm certainly not condoning what he did. He killed a woman.
He killed a woman, and it was wrong. But does the sentence meet the crime?
Exactly.
It doesn't.
Because there's people who, will drive drunk and kill someone, and their maximum sentence is 15 years.
Mm-hmm.
It's kind of the same thing. It's a unplanned, a not premeditated scenario, and they keep putting this guy in and out of jail.
Well, and it's also you have to play by the rules,
and the rules go for everybody.
And as obviously right now, what's happening, a lot of things aren't going by the rules, and that's why everything is chaos.
Yep.
But that doesn't mean that we don't have the rules for a reason.
Yeah. Wow. Yeah, that's crazy. in and out and like free and not free, and family starts to intervene because they want money, not because they care about mom.
Well, and like
I think that's what really chaps my ass the most.
Well, on two psychiatrists, like he's not likely to reoffend.
Yeah.
Just keep up with your mental health treatment, get your EMDR, you'll be fine.
Yeah, look at the light.
Yeah.
Get those electrodes for your ears.
Yep. I made Kyla test all of my little things before I tried them on patients.
It's like, hey, can I put these electrodes on your ears? It's going to put a mild current through your brain. I was like, yeah, go ahead. Let's see what happens.
But she felt so much better afterwards. She felt much more relaxed.
Yeah, I don't know if it was the current or the
buzz.
3 glasses of wine that I had in addition, but...
My clients don't get the 3 glasses of wine, so...
Wow. Yeah, this is crazy. Wow. And as someone who was a funeral director, when you watch the movie, like I said, it's lighthearted. They kind of make light of a murder. Like, this guy killed somebody. Let's not forget that.
But the whole situation is
But the whole situation,
pants.
This is bonkers. Like, the police coerce him because he doesn't want to be outed or whatever.
None of the attorneys can stay in their lane.
Yeah, everyone's just like crossing all these ethical boundaries, and this poor guy is at the middle of it.
Bernie is the sanest one out of all of them, and he murdered somebody.
He murdered someone and left her body in a freezer for like 9 months.
Like, on top of, like, the pot pies.
Yeah, like, how is the nicest guy in this story the one who killed somebody?
And everyone's like, Team Bernie.
Yeah. I think Bernie has served his time. As the psychiatrist had said, he's not a danger. This was a one-time perfect storm. He's not going to go out. Now, if Bernie goes out and starts hanging out at, like, the nursing home, we might have a different opinion.
Like, I feel like maybe he should be blacklisted from that.
Yeah, maybe he needs to trespass himself right out of there. But judging by what he did when he was out for those 2 years with the director, he just kept to himself and, like...
Yeah.
He doesn't seem like the kind of person who really wants to draw attention to himself. He just kind of wants to do his thing.
Yeah. So, we're interested in hearing what people have to say about this story and about this episode. So you can find us on Facebook and Instagram. Just look up Buzzed and Baffled. Yeah. Or you can go to buzzedandbaffled.net, see our smiling faces, and learn more about us.
Yeah, we're going to have some really good, totally true pictures of us looking at this board that we've created.
I went all out, guys. I need you to appreciate it.
All right.
Okay. We will see you guys next time.